Most drivers do not lose their rights because they don't have them. They lose them because they volunteer them away. That statement makes people uncomfortable. We grow up believing rights are automatic, that if we've done nothing wrong, the system will sort itself out, that fairness is built into the interaction. But I have spent years watching body camera footage from the front row, watching what people say when the red and blue lights start flashing, watching how officers phrase questions, watching how judges later dissect those moments in suppression hearings. And I can tell you something that almost no one wants to hear. The Constitution protects you quietly, but it only works if you activate it. And that activation is not dramatic. It is not aggressive. It is not theatrical. It is a sentence. I am invoking my constitutional rights. That is the anchor. That is the phrase. And if you do not rehearse it until it becomes automatic, stress will erase it from your brain when you need it most. Picture the scene. You're driving home at night. Maybe you were slightly distracted. Maybe you rolled a stop sign just a little. Maybe you didn't. The lights hit your rearview mirror and your pulse spikes before your mind even processes what happened. Your hands tighten on the steering wheel. Your breathing changes. Your brain goes into what psychologists call threat mode. Adrenaline narrows your focus. You become compliant, eager, agreeable. Not because you're guilty, but because your nervous system wants the danger to go away. That physiological response is the first trap. Here's where this gets complicated. The Fourth Amendment protects you from unreasonable searches and seizures. The Fifth Amendment protects you from being compelled to incriminate yourself. The Sixth Amendment protects your right to counsel. Those are not abstract principles sitting in a law textbook. They are active shields, but shields only work when you raise them. And the system is designed around ambiguity. An officer approaches your window and asks, "Do you know why I stopped you?" It sounds conversational, it sounds harmless, but that question is not designed to inform you. It is designed to elicit a statement. If you say, "Yeah, I was probably going a little fast," you have just provided an admission. If you say, "No, why?" that's fine. But notice what's happening. The interaction is being shaped by your words. Now, this is the part most people misunderstand. Officers are allowed to ask questions. They are trained to ask questions. They are trained in conversational control, in reading body language, in silence as leverage. They are not required to tell you the full scope of what they suspect. They are not required to inform you that you are helping build probable cause with every volunteered sentence. Miranda warnings do not attach during routine traffic stops because, legally speaking, you are not in custodial interrogation, at least not yet. So people talk. They explain, they fill silence, they justify, they attempt to appear cooperative, and in doing so, they slowly convert a minor stop into something else. This is the trap. The Constitution does not prevent an officer from observing what is in plain view. It does not prevent them from acting on the smell of alcohol, the odor of marijuana, or visible contraband. It does not prevent them from running your license and checking for warrants. What it does prevent, unless an exception applies, is expanding the scope of the stop without reasonable suspicion or probable cause. But reasonable suspicion is a low threshold. It can be built from fragments, nervousness, inconsistent answers, delayed responses, furtive movements. These are subjective terms. They live in gray areas, and gray areas are where rights are lost. I've reviewed footage where a driver was stopped for a broken taillight. The officer asked where he was coming from. The driver hesitated, said a friend's house, then stumbled over the friend's name. Perfectly human behavior under stress. The officer later testified that the driver appeared evasive and unusually nervous. That contributed to reasonable suspicion. The stop expanded. A K-9 unit was called. The dog alerted. The vehicle was searched. Drugs were found. In court, the defense argued the detention was prolonged without justification. The prosecution pointed to the video. The shifting eyes, the inconsistent answer, the trembling hands. The judge ruled the officer had articulable suspicion. Motion to suppress denied. Now ask yourself, what would have happened if, after providing license and registration, the driver had calmly said, "Officer, I am invoking my constitutional rights. I choose to remain silent and I do not consent to any searches." That sentence does two things. It invokes the Fifth Amendment right to silence. It denies consent under the Fourth Amendment. It signals clarity. Let me be honest with you. It will feel awkward. It will feel confrontational. It will likely change the tone of the interaction. Officers are human beings. Some will respect it immediately, some will test it, some will interpret it as suspicious. But suspicion is not probable cause. Discomfort is not consent. This is where it turns. Consent is the silent killer of Fourth Amendment protection. Courts have ruled again and again that if you voluntarily consent to a search, the search is lawful. Even if you did not know you could refuse. Even if you felt subtle pressure. Even if the officer's voice was authoritative. As long as it was not overtly coercive, the consent stands. Body cam footage often shows this moment. Mind if I take a look in your car? The tone is casual, friendly. Sometimes there's small talk beforehand to build rapport. If you say, "Sure, I've got nothing to hide," the legal analysis is over. The search is valid. It does not matter that you felt you couldn't say no. That is why the phrase matters. I am invoking my constitutional rights. It is not disrespectful. It is not accusatory. It is not argumentative. It is precise. It moves the interaction from conversational ambiguity into constitutional clarity. Now here's another layer. The Fourth Amendment allows certain exceptions to the warrant requirement. Automobile exception, search incident to arrest, plain view doctrine, inventory searches, protective sweeps. Each of these has boundaries. Each of these has litigation history. But what often triggers those exceptions is something said or done during the initial interaction. An officer asks, "You don't have anything illegal in the car, do you?" That's not a question about your driving. That's fishing. If you nervously laugh and say, "No, just some stuff in the trunk," you've just directed attention to the trunk. If you say, "There's nothing you need to worry about," that ambiguity can be interpreted as evasive. The safest legal path is silence paired with clear invocation. Now, this is the part most people misunderstand. Invoking your rights does not magically end the stop. The officer can still issue a citation. The officer can still run checks. If they develop independent probable cause, they can act on it. But what you have done is prevent your own mouth from becoming evidence. There is psychology here that no one talks about. Officers are trained to detect deception. They are trained to interpret stress cues. But stress is universal during police encounters. Innocent people sweat. Innocent people stutter. Innocent people forget details. When your amygdala fires, your cognitive processing narrows. Your speech patterns change, and those changes are often interpreted as guilt. So when you speak freely under stress, you increase the chance of inconsistency. And inconsistency, even trivial inconsistency, can be articulated later as suspicious. Let me give you a realistic case example. A woman was stopped for failing to signal. The officer asked where she was headed. She said, "Home." He asked where home was. She gave an address but misspoke the zip code. The officer asked again. She corrected herself. On video, you can see the stress. Later, the officer testified that her inconsistent answers raised suspicion of criminal activity. He asked for consent to search. She said yes, hoping to end the stop. A small amount of contraband was found in a purse belonging to a passenger. In court, we argued the consent was not voluntary because of the coercive environment. The judge disagreed. The video showed polite tone. No threats, no drawn weapons. Consent deemed voluntary. Now imagine if, instead, after providing identification, she had said calmly, "Officer, I am invoking my constitutional rights. I choose to remain silent, and I do not consent to searches." The dynamic shifts. The legal record shifts. The officer may still investigate within lawful limits, but the evidentiary pathway narrows dramatically. Here's where this gets even more nuanced. There are moments when silence alone is not enough. The Supreme Court has held that the right to remain silent must be clearly invoked. Simply refusing to answer without stating the reason can, in some contexts, allow continued questioning. That is why the phrase must be explicit. I am invoking my constitutional rights. Not vague, not sarcastic, not aggressive, clear. Now let me give you the hard truth. Asserting your rights may make the encounter longer. It may make the officer less friendly. It may result in a canine sniff around your vehicle. It may mean you receive the citation instead of a warning. Rights are not convenience tools. They are protection tools. You have to decide what you value more in that moment, a pleasant interaction or a preserved defense. There is also body language. Keep your hands visible. Move slowly. Announce movements before making them. Do not argue roadside law. The roadside is not a courtroom. The officer is not the judge. If they say they are searching despite your refusal, do not physically resist. Say clearly, "I do not consent to this search." Then be silent. That sentence preserves the issue for court. If they ignore you and search anyway, your battle shifts to suppression. And suppression hearings are won or lost on the record created in those first minutes. Judges watch the footage. They analyze tone. They analyze words. They analyze whether consent was unequivocal. When you rehearse the phrase, you are not being paranoid. You are preparing for stress. Under adrenaline, complex language disappears. That is why the phrase must be simple and memorized. I am invoking my constitutional rights. There are gray areas, of course. If you are lawfully arrested, certain searches incident to arrest are permitted. If contraband is in plain view, no consent is required. If a dog alerts during a lawful stop that was not unreasonably prolonged, probable cause may arise. These are litigated details, but your invocation never hurts your legal position. Volunteering information often does. And let's talk about the psychology of authority. Humans are wired to comply with perceived authority figures. Uniforms trigger obedience responses. Tone of command triggers deference. That is not weakness. It is conditioning. The Constitution exists precisely because power imbalances exist. When you assert your rights calmly, you are not escalating. You are balancing. Some officers will attempt to reframe your invocation. Why won't you talk if you've got nothing to hide? That question is a psychological lever. The implication is that silence equals guilt. Legally, that is false. The Fifth Amendment exists because innocent people can be ensnared by their own words. If pressed, repeat the phrase. Do not elaborate. Do not justify. The more you explain why you're invoking rights, the more you are speaking. This is where discipline matters. You do not need to educate the officer. You do not need to debate case law. You do not need to win the argument on the roadside. You need to preserve the record. Over the years, I have watched countless videos where the difference between dismissal and conviction was a single sentence spoken in the first 3 minutes, a casual admission, a nervous joke, a volunteered explanation. And I have also watched cases collapse because a driver calmly, clearly invoked rights, denied consent, and refused to be baited into conversation. The system runs on words. Prosecutors use them. Judges analyze them. Jurors hear them. Silence, when properly invoked, is powerful. So here's what I tell every client, every friend, every family member. Rehearse the phrase. Say it out loud. Say it until it feels natural. I am invoking my constitutional rights. I choose to remain silent. I do not consent to any searches. Because when the lights hit your mirror and your pulse spikes and your brain floods with adrenaline, you will not rise to the occasion. You will fall to your level of preparation. And in that moment, clarity is everything.